Okay, good morning. I'm going to call to order the special call board meeting of the KPPA, and we're going to begin with a legal public statement.
Thank you. For the record, I want to note this is a special meeting of the Kentucky Public Pensions Authority. This meeting is being broadcast via video teleconference pursuant to Kentucky Revised Statute Section 61.826 and may be viewed by the public at the Kentucky Public Pensions Authority offices located at 1260 Louisville Road in Frankfort, Kentucky. It is also being broadcast to the public via Facebook. I ask if you are speaking and are not appearing by video, please identify yourself before talking. In the event the video or audio broadcast is interrupted, we will attempt to reestablish a connection. If a connection cannot be reestablished within 30 minutes, the meeting will be adjourned and rescheduled to another date. Thank you.
Okay, roll call.
Yes, sir. Mr. Piercy,
Here.
Dr. Hackbart,
Here.
Ms. Hampton,
Here.
Mr. Lane, Mr. O'Mara,
Here.
Ms. Pendergrass,
Here.
Mr. Powell,
Here.
and Mr. Summers.
Here.
Thank you.
Any public comment?
No, sir, no public comment.
Okay, we move on to the chief auditor contract, and Michael Board's on the agenda to discuss that.
Yes, so thank you all for being available today to come back. As you know, at the board meeting on September 28th, I believe, the board approved this contract to be offered to Ms. Coffey as for chief auditor position. I sent her this contract, copied Mr. Piercy as the board had directed on those emails. And there were a few emails exchanged back and forth. Ms. Coffey, I think she's present today. I'm not going to speak for her, but she had requested some amendments or changes or things to be included or changed from the contract. And I had advised her that, neither I nor Mr. Piercy had authority to do that on behalf of the full board. Things of this nature would have to be brought back to the full board for discussion. And so we're here today to discuss those things. And so, Ms. Coffey, I think I saw you present. You're not currently on my screen, but I don't want to speak for you. I'm happy to run through, what you sent me. But if you want to speak for yourself, that would be much preferred, so I don't mischaracterize anything.
I am here.
Okay.
I'm happy with either way that the board would like to move forward. You can go over it, and then if something isn't exactly what I was thinking, I can chime in or I can go through them either way. Okay.
I'm happy to just run through the three things, and please, if anything is not accurate, please feel free to chime in on that and correct anything that needs to be corrected. Okay. So there's three things that first I'll say there were a few typographical errors that I corrected throughout the contract. Mainly, I used Mr. Eager's contract as a template, and I had failed to change a few of the his to hers. Ms. Coffey noted that, and so I changed those. In the first thing Ms. Coffey requested was she thinks it would be beneficial to add a reference to the internal audit charter, since it describes how she is to conduct herself in carrying out the charter mandate. So that's number one. And I'll come back and deal with these in turn once we go through the three items. The second one is under paragraph 5A, and Sherry, I think that is on page 2 of 7. It said her request is the current third paragraph under 5A has an undefined cause by using the phrase shall include but not be limited to. Perhaps removing that and adding the charter reference would suffice. And then the third reference asked if paragraph 5B, which is the termination for cause section, could be removed because the current language seems to construct an at-will situation as opposed to a contractual commitment with a term. And so, Ms. Coffey, did I accurately reflect the request that you made?
You did. The other thing with 5B is if it couldn't be removed, just to maybe update the language somewhat, just so it's less of an at-will and more of a contract situation.
So that's the three items, and thank you for that clarification, Ms. Coffey. I will go back to number one, and then open it up to the board members for discussion. I will just offer that I think if the board is amenable to number one, I think in reading the contract, I think maybe the proper place to do so, to add a reference to the internal audit charter, would be on page one, under paragraph number one, under duties. I think the proper place to maybe add that, if the board was amenable to doing that, would be under that section. There's a phrase, the second sentence states that the employee will report to the board of the Kentucky Public Pensions Authority Board and shall perform her duties and discharge her responsibilities competently, carefully, and faithfully as required herein and in the KPPA policies as applicable. I think there's room in that sentence to add a reference to the charter as requested if the board wishes to do that. And then, the board can move through numbers 2 and 3 request as they see fit.
Hey, Michael, if
Go ahead, Rebecca.
they include an external document by reference that gets updated more often than the contract, how does the update work?
It would just, the document is referenced as long as that document exists, whatever form it exists in is what's going to be applicable to the contract. So,
Could we add the parenthetical phrase, comma, as amended, comma?
yes. That would not be a problem.
Yeah, I don't personally have any issue with adding those, that to the contract about the audit charter.
I don't either. I think that's fine. And I think Betty's addition is good.
I agree.
Yeah, I don't see where that's a problem.
Looks like we're fairly, looks like we're in good shape on that one. Anyone want to voice an opposition to that particular change? Doesn't look like it. Okay, we'll move on to the second one.
And so the second one is, as I mentioned earlier, was regarding paragraph 5A, that the phrasing, as you'll see in the third paragraph, starts as used herein, calls shall include but not be limited to the following. And the request, and again, Ms. Coffey, if I'm mischaracterizing this or misreading it, please chime in. But the request is that that phrasing has an undefined cause by using the phrase of shall include but not be limited to. And she says perhaps removing that and adding the charter reference would suffice. And so that's up for the board's discussion.
Michael, is this language here, is it consistent with the other contracts we have? For instance, for Mr. Eager, John Chilton, Ed Owens, is that language that's already in what we're looking at, is that consistent with what's in those other contracts?
It is consistent with Mr. Eager's and Mr. Chilton's, and I'm 95% certain it's consistent with what's in Ed Owens. And Johnson Bowman did that most recent update, but I have seen it, and I think it is 100% consistent. Ms. Pendergrass may be able to answer that 100% accurately.
I would say 96. I'll go find his charter or his contract.
but I'm nearly certain it is exactly what's in there. But for Mr. Eager and Mr. Chilton, I know it's the same thing. I've used those contracts as templates and did not change anything.
So why would we change it here?
Yeah, I mean, I think that's a good question. Kristen, are you still with us?
I am.
Okay, so I guess my question would be, is it specifically the fact that it says, but not limited to, is that what you're objecting to?
It is. It was just that because you're listing termination for cause and you're listing all the reasons for cause, but then it says not limited to. So it just, and to me, if you leave 5B in there, that seems to cover the not limited to. It was just it was just something I was pointing out. I'm not saying it has to be changed. It was just feedback.
Okay,
It is exactly the same in Ed's contract. I just looked at his updated contract that we did this year.
okay, so we have a situation where that exact language is in all the other contracts that we've entered into with the other employees. So nothing is different in this one when it comes to that language from the others. So I understand what you're saying. I also think that it's impossible to list all the possible reasons in every contract. I mean, there would be thousands probably if you really got down and started thinking about all the reasons that could be for cause. So I'm good with leaving this language as is, and we'll listen to the rest of the board.
I agree.
I don't see any reason to change it.
I'm okay with just being consistent across the board.
Okay. Any objections to that? Okay, let's move to the third.
And the third item was asking if the language in paragraph 5B, termination without cause, could be removed or at least softened. The current language seems to construct an at-will situation as opposed to a contractual commitment with a term. And Kristen, I apologize. The first time I read that, I missed the or at least softened phrase in your message. So I apologize. You clarified that, and I appreciate that. So, and Mr. Piercy, anticipating a similar question, this is the same language included in the other contracts with one exception. This phrasing is included in the other contracts that we have with Mr. Eager, Mr. Chilton, and Mr. Owens. And I see Ms. Pendergrass giving a thumbs up. However, I believe in those contracts, there's also what's commonly referred to as a parachute provision included in those contracts. So just for the knowledge of the board, of the rest of the board members, there's another part of this clause in those contracts.
Okay, in Mr. Eager's case, when he had a 2-year contract, what you're referring to as a parachute was 6 months, right? If he was terminated without cause, he either got compensated for 6 months or the remainder of the contract, whichever was shorter, correct?
That's correct. Yes.
Okay. Once he converted to a 1-year contract, then that clause reduced to 3 months, correct?
That is correct. Yes.
Okay. John Chilton's current contract calls for, it's a 2-year contract and he has a 6-month term, correct?
That is correct and I'm going to confirm that, but I looked at that just a couple of days ago, and I believe that is accurate. I'm going to double check that as we're speaking to make 100% certain.
Okay. And then Betty, for Ed,
He has a 3-month.
with a 2-year or 1-year contract?
Let me double check that. Hang on. Two-year contract.
2 years and a 3-month without cause term of pay. Okay. So
I have one question. We have some other, and this question's for Lori. We have other division directors. And also our executive directors. Do any of them have contractual arrangements with balloon payments, or are they all at will?
They do not have any parachute payments. They're regular non-merit employees. So there's no contractual agreement or balloon payment.
And they are all at will?
Yes.
Thank
I
you.
will say, just in regards to that, I think the difference is all of those individuals are still subject to Chapter 18A. Whereas the employees we're talking about on the contracts are outside of 18A per statute. But Mr. Piercy, I did just confirm that Mr. Chilton's is 6 months on a 2-year contract.
okay, so the consistent thing is all of these contracts have some period of payment if you're fired without cause. There's an inconsistency in the length. So that's, up for debate, but they all do have some period of payout. And the question is, do we want to do anything to modify that particular section?
I would think that we would follow the consistency of the other contracts with having that option. And then, I'll put out the 3-month and then see where that goes.
This is a 1-year contract, isn't it?
It's
It
2.
is, yeah, it's currently drafted for 2.
Well, I don't know why one would have a 6-month on a 2-year contract and would have a 3-month on a 2-year contract. Why did we do that? Why was that done?
We had 2 different boards involved. The C board did the 3-month for a 2-year contract, and the K board did a 6-month for a 2-year contract. It's just the autonomy of the boards.
I think a 3-month is reasonable.
I can agree with 3-month as well. William, what do you think?
I think we need to be consistent. So if we're gonna have one, I don't know what the outlier is, what months. I think we need to be consistent. I'm just looking at it from a standpoint of, I don't want to always be talking about race, but you got a white gentleman, 6 months, 2 years. You got an African-American gentleman, 6 months, 3, and then you're gonna have a woman that is gonna be 3 months. So I think we need to work to be consistent.
It's difficult to be consistent because the other contracts are in place.
I support what William's saying. I think we can be consistent in KRS with our 2 contracts being 6 months, and then we have a new one that's going to come up in the near future that we will have, an opportunity to look at this from the executive director standpoint. And if CERS wants to keep theirs at 3 months, I think that's the privilege they have. But I would go along with William and say 6 months, and hopefully we never have to use this.
I thought we said that David Eagers was 3 months.
For a 1 year, correct.
It's a 1-year contract. When Mr. Eagers was a 2-year contract, it was 6 months as well.
I just think we got to be consistent no matter what. Man, I'm not saying that you can amend other things, but whatever we decide to do, I just think we need to be consistent.
I agree
And
with
I
what
would agree. I can go back to the CERS board and ask them about Ed's.
Yeah, I agree with what you're saying, William, but I think Merle's point earlier, it's hard to be consistent when you have 2 autonomous boards that have decided 2 different things and those contracts are already in place.
Betty,
But
how
I
much
do,
time?
I do.
Sorry, how much time is left on Ed's? I know when we redid John's contract this year, we made it 2 years. It had been one.
Ed started with a 2-year contract, and this year, 2023, it came up for a renewal. So we renewed it for another 2 years.
Again, I'm comfortable with 6 months.
Okay, it sounds like on the first two changes, we're good to go. The question is this third one. I'm trying to think of the best way to do this.
One
I
other
guess-
question, Steve Willer's contract is outside 18A.
We are in the current, he doesn't have a contract at the moment. We're currently working on that issue as we speak.
Okay,
We're currently drafting that and trying to put that in place.
okay.
What is the, if, are you looking at the same 6-month parachute or in that one, or have you got to that point?
Currently as drafted, it's 3 months. But obviously hearing this discussion, we will, that's not finalized, obviously.
Are there any other
document?
Are there any other comparables in other state organizations, like teachers, for example? I mean, to be consistent, there probably should be some guidelines authored by some reasonable party. Otherwise, we're trying to be consistent, but it's very difficult. I think the idea for that is very is appropriate, and that and I'm just trying to think about opportunity, why termination might be applied. It might be because of financial contingencies and so forth. So I'm just not sure what would be the reason outside of a violation of the standards of the contract.
Well,
I don't think this would make anybody happy, especially Kristen, is we could be consistent by making it a 1-year contract, and I'm not supporting that.
I think Burl makes a good point there. Michael and I actually talked about this the other day. Since this is a statutory position, I'm not sure how the board would ever terminate it without cause anyway. So I guess the only way I know to go about this is anybody willing to make a motion that includes the first two changes that we've agreed to and just throw out what they think is appropriate for the third?
Sure. I make a motion that we make the first amendment and the second amendment as suggested by Kristen and amended by us a little bit. And I would like to add that the umbrella be set at 6 months.
Second.
That's not what we said on number 2.
And I was going to ask for that as well, Ms. Pendergrass. Thank you. That I believe the number 2, the consensus that I heard. Just I want to be sure, because I'm going to be the one making these changes. I just want to make sure that I'm clear that the consensus of the board that I heard was we would make the change requested in number 1 in that opening paragraph under duties, and then under number 2, the consensus was we were going to leave
Change.
paragraph 5A alone. And then Ms. Hampton made a motion to add to paragraph 5B the language of a 6-month parachute.
That's
That's
correct. I'm sorry the way I said 5 as amended. I really, okay, sorry about that.
Okay. Do you want to restate that motion, Lance, so we're clear?
Okay, I'd like to make a motion that we amend the section 1 to add some language that clarifies, and that we amend 5 5A or 5B to add an umbrella of 6 months. Is that
Okay,
correct,
William?
Michael?
Okay, Williams, your second stand.
Yes.
You need
long as we-
parachute, do you
what
not?
we- Oh, I don't, it's just adding the 6 months, basically, in my opinion.
Yep, correct. Okay. All right, we have a first and a second. Any discussion?
Keith,
Yes.
Lynn used the term umbrella. I think she meant parachute, did you not?
Yeah,
Yes.
we've been using some interchangeable terms here, but yeah, I think she meant a 6-month parachute. Okay, we have a first and a second. Any discussion? Seeing none. All those in favor?
Aye.
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 Opposed? Okay, that motion carries. We're good on the contract, Michael?
We are. I can make those changes. I will get those done as soon as I possibly can, and I will, Ms. Coffey, I will get you an updated draft of this as soon as I get those changes made. I'll get that back out to you. It will be before the end of the week. So I'll get that to you as soon as possible.
Okay. Thank you very much. Our next item is a closed session for litigation, and I'll entertain a motion.
So moved.
I'll second.
Any discussion? Seeing none, all those in favor?
Aye.
Aye.
Opposed? And the motion carries. The motion having been made in open session to move into closed session for a specific purpose, and such motion having carried by majority vote in open public session, the board shall now enter closed session to consider litigation pursuant to KRS 618101C. Because of the necessity of protecting the confidentiality of the system's litigation strategy and preserving any available attorney-client privilege. So we're in closed session. Sean, take